And now I would like to introduce today's speakers. Edwin Broker is a partner in our business law practice group and a member of the corporate venturing team. He balances business results and mitigation of legal risks, concentrating his practice on commercial agreements, corporate and board governance, software licenses, finance and equipment leases, and helping clients in transitional situations, including asset monetization, business expansion, and capitalization. He represents a broad array of national and international clients, with concentration in the fields of advanced manufacturing, IT and life sciences, sales and distribution, and hospitality and gaming. Ed has a great deal of experience in supply chain matters, international trade, and compliance program creation, improvement, and related training, counseling, and assessment. He regularly speaks on business, corporate, and compliance matters at national and international law conferences. E. Christopher Johnson, Jr. is the co-founder of the Center for Justice, Rights, and Dignity and chair of the ABA Business Law Section CSR Subcommittee on implementation of the ABA Model Principles on Labor Trafficking and Child Labor. He is a West Point graduate and retired Vice President and General Counsel of General Motors North America. After retiring from GM in 2008, he founded and directed the graduate program in corporate law and finance at Western Michigan University Thomas Coley Law School. Chris, who is a decorated Army veteran, has been recognized for his contributions to the bar and community by the ABA, State Bar of Michigan, Detroit Metropolitan Bar Association, National Bar Association, and other organizations. Fernanda Baraldi works for Cummins, Inc. in Indianapolis as Director, Ethics and Compliance International and Corporate Counsel. She has 14 years of experience and is a dual licensed attorney in Brazil and Indiana. She graduated from Mackenzie University in Brazil and also holds a Master of Laws degree in Corporate and Commercial Law from Robert H. McKinney School of Law in Indianapolis. Fernanda has been to over 50 countries for business and is interested in compliance and its cultural aspects. She has experience in offsets, export control, anti-bribery regulations and enforcement, interaction with government officials and SOEs, and development and implementation of global policies and training. Now I'll turn it over to our speakers.
Thank you, Kathleen. One housekeeping point. Unfortunately, Chris had a death in the family, so he is not here physically, but he is on the line. So he will be participating, and we'll be jumping in a couple of minutes. So with that, let's begin. So we're all here today. We have the agenda on the importance of the supply chains, and our main topic is supply chain transparency. And for all of those who are not familiar with the term, it is essentially slavery. So when you see transparency, when it relates to supply chain, just insert the word slavery. And so the agenda, we're going to talk about how supply chains are very crucial to your business. Then we're going to go into some of the legislative and regulatory issues relating to transparency. We're going to follow up with some highlights from some recent litigation matters that are directly on point, and then we're going to conclude with the question and answer session. So when we talk about the supply chain here, everybody knows how important business is and how hard it is to operate. And when I saw this slide, it just it made it hit home on just how important and how risky doing business in a global environment is. So we all know the adage about a chain is only as strong as its weakest link, and in the supply chain, there's no difference. I don't know if everybody remembers a couple of years ago when the tsunami hit Japan, how critical and devastating that was to the U.S. auto manufacturers and all the auto manufacturers across the world. For example, I think Toyota reported a loss directly related to one supplier that was affected from that tsunami of $3.2 billion, and Honda reported a loss of over $900 million. So just one supplier in one location in Japan caused over $4 billion worth of damages to two auto manufacturers. So knowing who is in your supply chain, where it is, and the issues associated with it are critical to all of you business folks. And as you can tell, supply chains are getting longer, more complex, and definitely more international. I picked up this slide from Comparacamp, which showed that the iPhone 6 traveled through roughly 785 suppliers in 31 countries and literally touched over 1 million hands, either by physical touching or robotic arms touching the product. And so it is an amazing journey on how complex just a simple little iPhone is, that it has to travel all over the world on multiple occasions just to get to the final endpoint. So with that, we all understand that globalization creates risk. And as business lawyers, we are here to try to minimize those risks and maximize opportunities for our clients. And so when we review contracts, we all understand the general natures. We all want to protect our customers from supply chain delays, so making sure that our product arrives on time when it's expected, so then we can operate and then turn around and ship it back upstream. We all understand that we need to mitigate all the other risks associated with the contract and the delivery. We want to make sure that our suppliers comply with the law. There are various laws that are applicable to the situation. We pulled up this slide right here, and that just kind of highlights as the product moves through the life cycle from raw material through to distribution, just some of the risks that may be associated with it. You got export control issues, you got health, safety, environmental related laws that are applicable, you got fair competition, you got anti-corruption issues. And so when you draft agreements and supply contracts, you always need to be cognizant of those issues, and you need to make sure that you have the appropriate balance of rights and responsibilities, and then most importantly, you need to obtain audit rights so that you can make sure that when something happens, you have the ability to go and inspect your supplier, and they can't turn you away. So with that, we're going to talk about, on the left-hand side, and I can't point, I don't have a laser pointer, but the little yellow icon, and right below it, the transparency button. That's going to be our next topic. So with that, I'm going to turn it over to Chris, and he's going to talk about some legislative and regulatory responses in the United States.
Thanks very much, Ed, and can everyone hear me?
Yes, we can.
Okay, great. Thank you, and I'm sorry again that I couldn't be there, and thank you for accommodating me remotely. The first one is the Dodd-Frank Act in conflict minerals, and this, as you know, was enacted back in 2010. It involves this war that's been going on in the Democratic Republic of the Congo, civil war that broke out in 1998, and since then some 5 million people have been killed. They say it's the most deadliest conflict since World War II. So anyway, these conflict mineral disclosures require companies to disclose whether or not products were manufactured there as a way to, and the manufacture of these precious minerals that are found in this area, which include gold ore, diamonds, tin, tungsten, and coltan, which widely is used in smartphones, laptops, and other electronics. I want to make sure that the mining of these ores is not continuing to fuel this conflict. So, and it was the first instance where you really had a regulator required supply chain disclosure. There have been a number of challenges to the law, and most recently, two things have happened. One is that the acting SEC chief, Michael Pinawar, has taken steps to weaken enforcement, asking the staff and asking for public comment about reconsidering how companies should comply to this. But just recently today, I read that, and this is some reports that are coming out of The Guardian and Newsweek. There is a draft executive order, evidently, composed last week that proposes a 2-year suspension of the conflict minerals rule that supposedly President Trump is going to initiate. So this law is clearly under attack, and the implementation of it is really questionable going forward based upon what the SEC is doing itself, and the SEC is the organization that's administering the law, as well as what might be coming out of the White House. So stand by on this one. Okay, we can go to the next slide. Okay, so the next act we want to talk about is the California Transparency and Supply Chains Act, also in 2010, came out in 2010, effective on January 1st. And this is a group of laws. We're going to talk about a few others in the international space that are disclosure laws. And they require website disclosure for certain companies with receipts over $100 million, requires disclosures into how are you addressing this risk of human trafficking and slavery? Do you audit your suppliers, for instance? Do you require certification from your suppliers? And what is the internal accountability for employees and contractors who fail to meet your requirements? And for supply chain management. And if we go to the next slide, the problem is because it's just the disclosure law and doesn't require real action, it's threatening on the one hand, but toothless in that it doesn't require policies or due diligence, doesn't criminalize slavery. The one thing it did do, it helped usher in a period of transparency, and Ed mentioned that at the outset. And here you're talking about companies being required to talk about what they're doing, and you'll find various companies with various types of disclosures. And this transparency, and also you'll find this in some of the sustainability reporting, have the same types of questions about what you're doing with respect to this. So this creates obviously a disclosure risk, and obviously in these cases the companies are being very careful about what they disclose, what they're doing, for fear of running afoul of the SEC. So it doesn't do a lot of things, but it has ushered in this era. And one other thing I wanted to mention here is that what you're starting to see is more and more benchmarking being done by some NGOs. The Business and Human Rights Resource Center, has a corporate legal accountability report. The last one was on some of the litigation that we're going to talk about later. Know the Chain has published benchmarking reports with respect to certain industries. The garment industry, apparel and footwear companies were one, and so there are some situations where more and more transparency is coming out about what companies are doing and which companies are supposedly doing a better job than others in this area. There's another organization that's coming out with another report, the Corporate Human Rights Benchmarking. They're coming out with an initial pilot report in March 13th of 100 companies, and they want to go up to 500 companies. So you're going to see additional activity in this area reporting. And as you know, one of the big issues here is reputation. And Ed mentioned the word slavery. That's what people use. Human trafficking is different than slavery, and I've written a law review article that explains the difference, but it is essentially the same ill of exploitation of a human being by another or by an entity, essentially. So that's your problem. We can go on to the next slide about the Federal Acquisition Regulation. The Federal Acquisition Regulation was updated last year, and this started as an executive office order that President Obama wrote. And basically, there are a number of requirements here. This first set of requirements for contractors and subcontractors are from concealing or compensating immigration documents and misleading recruiting practices, charging recruitment fees, failure to follow and pay for return transportation. These are all recruitment practices, and many of these recruitment practices are engaged in by labor brokers, who are entities used by companies to find workers overseas. And unfortunately, there are a number of corrupt labor brokers who have engaged in bribery and other and these forms of all of these activities. You can see that if you take somebody's employee identification and immigration documents, they can't move, they can't leave, they can't. You're using these incidents of control to control the movement of people, and this includes misleading practices. So this is how people get in the bonds of slavery without there being actual chains by some of these practices. If you're talking about if you're talking about contracts, overseas contracts for more than $500,000, then you have to have a compliance plan, which includes an awareness program, whistleblowing, recruitment and wage plan, housing plan, and other procedures. So, and you have to post the plan annually, certify that it has implemented a compliance plan, and the other requirements noted. And recently, the Office of Management and Budget and the Office of Federal Procurement published some anti-trafficking risk management best practices. They've asked for public comment on those, and the ABA, through the Public Contract Law Center, I work with them on providing some comments back to the government about their proposed risk management process. And one of the comments we made is that the ABA model policies on labor trafficking and child labor, which we're going to discuss later, we recommended to the government, that is the ABA recommended to the government, that they consider using these model policies as a suggested best practice for managing risk in this area. So this is a very tough law, and obviously applies to government contractors of various different levels. So we can go on to Trade Facilitation and Trade Enforcement Act. This is another new legislative initiative, and one of the things you'll see about this area, you see a lot of new legislation. Just about everything I'm talking about goes back to 2010 at best, and realize that the first trafficking legislation didn't come out until 2000. So, but now you're seeing a increase with the updated federal acquisition regulation, and now this Trade Facilitation and Trade Enforcement Act really came out in 2016 as part of the Tariff Act, and it just as background, the Department of Labor maintains a list of products and countries for which are the reasonable basis to believe they're produced by forced labor or indentured child labor. And this list is on the Department of Labor's website, and it will tell you, for instance, that cotton from certain countries or other areas there's reason to believe that they have a significant interest. So this is one of these problems that a lot of people know about. As I said, there's a report on the Department of Labor website that talks about, I think, over 130 products in over 70 countries, that coming from over 70 countries that have forced labor or child labor. However, you wonder, well, wait a minute, so how do these things come in? Well, in the Tariff Act forbids. The Tariff Act says you can't have goods coming into the country that have forced labor or indentured child labor. So how do these how does the products get into the country? Well, there was a consumptive demand exception to the Tariff Act, and so which basically said if the goods were made with forced labor or child labor, they can be imported, but if there was a domestic need and the domestic production was insufficient. You can go to the next slide. So this act closed that loophole, and now U.S. Customs and Border Protection has established an anonymous reporting website. Anybody can go on the website and say, we think that X company's products have child labor, forced labor, and Customs and Border Protection will investigate, and they could seize the goods coming into the country. And you note there's the textile supplier, Tangsan Sanyu, whose products allegedly contain products produced with forced labor or forced prison labor. And, another seizure relates to stevia. Now, it remains to be seen, since this is a new act, and it remains to be seen what the new administration is going to do about this act, ramp up or scale back in terms of enforcement. Obviously, the Customs and Border Protection folks are going to be very busy in a lot of different respects, and so just don't know where this particular act is going to come out. But obviously, there's some significant risk here if your goods get held up. And for instance, Customs and Border Protection says, well, we have reason to believe that this good has forced labor or child labor, and they ask you what can you tell us about your actions, and you don't have any actions to discuss. So that could be a problem for a company that has goods. The Customs and Border Protection doesn't. They're obviously aware of the Department of Labor list, but it's not the only metric that they use, in their investigation. Just one of the tools. So it remains to be seen how effective this law is going to be, and that's going to be based on enforcement. And now I'm going to step aside for Fernanda to talk about some of the international legislative responses to this area as well.
Thank you, Chris. The first one that we're going to talk about is the UK Modern Slavery Act. So what we're going to learn in this section is what our friends across the pond are doing, the old world. They're already taking care of that issue as well, taking that matter to be seeing the importance of the matter. So the first one is the UK Modern Slavery Act. Very similar to the California Act with a few differences. It applies to companies that have 36 million pounds or more of revenue per year, global companies, which have a business presence in the UK, which is interpreted very loosely. So you don't want to really be arguing, well, I don't think I have a presence in the UK, so I'm not going to be compliant with the law. It requires a statement signed by a director describing the steps the company took during the financial year to ensure that slavery and human trafficking is not taking place in the supply chain and as part of their own business. It also requires the companies to have a disclaimer on the website. It has to contain the following. The disclaimer has to disclose the following. The company structure, anti-trafficking and anti-slavery policies, anti-trafficking and anti-slavery due diligence processes, identification of management of higher risk areas, effectiveness assessment, and an anti-trafficking and anti-slavery training made available to the staff. So if you hit all those checkpoints, you would be okay. But as I mentioned before, there's a little difference between the California Act and the UK Modern Slavery Act, because under the California Act, there's no criminalization of slavery, but under the UK Act, we do. So the UK Act specifically criminalizes slavery, servitude, forced labor, and human trafficking. But don't get too excited about it, because when you look at the third bullet, you can see the no extraterritorial jurisdiction for slavery committed outside the UK. So the thing is, well, we have this great law that criminalizes slavery, but it doesn't apply if you're a global company, you have business outside the UK. So what's the real point, right? You have a disclaimer, you're a global company, 36 million pounds or more, and then it does not apply for whatever you do outside the UK. Well, we're going to see some of the cases. Most of the cases of the things that happen are outside the US and outside the UK and outside those countries. So that could be seen as a little bit toothless as well. And it does not allow a private cause of action for victims of slavery. So you can see the balance here. Probably a lot of compromise when this law was passing. Another thing that we can talk about is the Directive 2014, which is from the European Union, which is a non-financial reporting directive that has been recently amended to include that public and private companies of a certain size, as determined by the number of employees, more than average of 500 or more, need to disclose information related to their policies, including anti-corruption, bribery, and respect for human rights, right? This was recently amended, as I mentioned, and the member states of the European Union have to implement this and localize, right, create laws in each one of those countries to mirror this directive by December 6, 2016. So last time we tracked, the member states were still chasing the implementation of this directive at a local level. Another thing that's being got a lot of buzz, a lot of attention, is the France devoir de vigilance rule. It's a law that obligates a proposed law that obligates large companies to carry out a vigilance plan, and the companies will be held accountable for failure to adopt a plan if the plan is insufficient or if there's a default in implementation. So it's similar to the UK Bribery Act when you can be guilty or by failure to prevent bribery. It's the same thing here. It's failure to prevent human trafficking in your supply chain. Fines can be more than 10 million euros, which is a lot of money, right? But this law hasn't passed yet. It's the third attempt of passing the law. February 2nd, 2017, the law has been rejected again at the Senate, French Senate, and so it's back to the Assembly, France's Assembly for amendments. Other countries that are also considering passing human trafficking supply chain transparency law are the Netherlands, Switzerland, Germany, Austria, Italy, Sweden. So as you all can see, it's kind of like it's a swell of countries, right? It's a lot of countries trying to work on that. The OECD, as you can see how timely and important this issue is, just published today a due diligence guidance for responsible supply chains in the garment and footwear section. That was as of today. So that shows how important and timely this issue is. So now we're going to start to talk about litigation. Litigators hearing us are like, wow, we really want to hear about it, right? So there are mainly four different, I would say, strings here. Negligence is one of them. False advertisement, ATS, or the Alien Tort Statute, and the Trafficking Victims Protection Act. And we're going to talk about each one of those and cases that have been using those arguments and discussion. So.
Okay. Well, thank you, Fernanda.
Yeah.
You're going to see some of the major headlines that have been taking place revolve around the theory of negligence, and that is that the tier one company here, most specifically, generally the garment industry has been hit the hardest, and so JCPenney and the Children's Place and Walmart have all been sued on various theories of negligence, all relating out of the Bangladeshi factory collapse back in 2014, I believe. And the tragedy in that case was that the day before the collapse, the government inspectors came in and actually shut down the factory. They noticed cracks in the walls, and they forced everybody to leave the factory during the day. Unfortunately, the owners of the factory and the owners of the garment industry called up all the employees that night and forced them to come back into work the next day. And that's when the collapse occurred, killing over 1,100 women and children and causing countless numbers of other injuries. So back in May of 2016, one of the victims' families brought a negligence action against JCPenney and others in Delaware, alleging that the retailers knew or should have known that given the industry that they were in, that the suppliers were bad suppliers and that the employees were held in forced labor. And so they should have been more diligent in their efforts to eradicate the issues. Unfortunately, the court in Ramanan dismissed the case for two reasons. The first reason was under Bangladeshi law, there was a 1-year statute of limitation for these types of claims, and unfortunately, the plaintiff brought it after the 1-year statute of limitations. But importantly for our discussion today, the court went on and actually analyzed the theory regarding negligence, and it concluded that the negligence claims should be dismissed as well because while there was a peculiar risk of that the industry is fraught with poor working conditions, the court held that exception did not apply in this instance because it's general knowledge, but this peculiar the injuries that occurred because of the factory collapse, not just the industry. And so the court kind of took a narrow reading of that. And then we'll see later that the issue of having independent contractors or independent suppliers is going to be a big issue in here, just like in Doe versus Walmart. Having having an independent contractor serve as your supplier, as long as you don't control control how the process is occurring, generally insulates you from liability. Here in Doe versus Walmart, what happened was the plaintiffs alleged that Walmart's code of conduct essentially created, the code of conduct was actually incorporated into the supply agreement. So it really was a contractual obligation of the supplier to abide by the code of conduct, which contained all these wonderful requirements in flowery language. Unfortunately, though, the court interpreted those very narrowly and concluded that those supplier code of conducts were, while might be applicable in some instances, were not obligations, and so did not create this sort of joint employment sort of rationale. And this is where we're having a timely discussion on this as well. That keep flipping. The standard that was articulated in Doe versus Walmart was the direct and immediate control standard that was the general standard that most people understood and operated under, so that you're not going to be responsible for your suppliers and independent contractors because you don't have the direct and immediate control. But just in 2015, the National Labor Relations Board kind of threw out that entire standard. And I know that our Labor Department and I know that a lot of people have been discussing the Browning-Ferris standard throughout the industry, talking about that it's chaos now and nobody really knows what's going to happen. One can be held liable as long as the company merely affects the means or manner of the employee's work in terms of employment through an intermediary. And, a lot has been discussed about franchises and whether the Browning-Ferris standard will apply in the franchise situation, and I know that it's a scary situation. The Browning-Ferris case is currently on appeal in the D.C. Circuit Court of Appeals. There's going to be oral argument next month. No decision has been reached yet. With the new administration, it's a question whether or not, the Department of Labor or the NLRB will continue to pursue these sorts of cases, but the applicability as it relates to transparency is real, and that is that some of the trade unions have been trying to create a joint employment situation based on articulated CSR policies, corporate social responsibility policies, that companies articulate and try to abide by. One specific example was the Microsoft case last summer, in which one of Microsoft's one of Microsoft's tier 1 suppliers was involved in a negotiation with a trade union based on the fact that Microsoft has a CSR policy that requires its suppliers to provide 15 days of paid leave. That trade union tried to bring Microsoft in as a joint employer and try to force the supplier to abide by that 15-day period or 15-day paid leave claim, and were initially they survived a motion to dismiss, so in the NLRB standard. So that was enough to send shockwaves throughout the industry that this joint employer situation is going to be real. And is an issue for corporations that try to do the right thing, try to create viable CSR policies, and want to better the environment. So stay tuned. After oral argument next month, we'll have a lot more granularity on the joint employer standard. So.
Well, another string of argument, as I mentioned before, is the false advertisement claims. What happens here is we have three different types of cases, but one of the first ones here is the National Consumers League versus Walmart. What happened is that the plaintiffs alleged that Walmart had the statement in the site and their website, and the statement was misleading, right, in regards to the use of force or child labor in the supply chain. It said that Walmart was against slavery, the Walmart didn't use or was intended not to use forced labor in their supply chain, and then the Rana Plaza building collapse happened. So the plaintiffs say, look, you have all this beautiful statement on your website, but this just happened with your second or third tier supplier. So that's a problem here, right? You are stating here in your website that you don't do this, and your supplier is doing that. So it's false advertisement. You're leading your consumers to buy based on this as well, but you're not abiding by what you're saying yourself, right? The court dismissed the claim because they said the policy statements were aspirational and that were not actionable because no reasonable consumer would construe those statements as definitive promises of what corporations will do. So it's a very, very interesting case. Another thing that we have is the chocolate cases and the fishing cases. So chocolate cases, Hudson versus Mars and Worth versus Mars, Dana versus Hershey, omission of mentioned child and slave labor in the supply chain. It's a wide known fact that child labor is employed in the cocoa industry. So by not mentioning it, you're not making disclosures that you should be making about your product. They also lost this case. The plaintiffs lost this case as well. Not actionable when the defendants did not make a false representation and the omission did not go to product safety. So because it was not related directly to product safety, it was not a false advertisement. Phishing cases are also the same. Sud versus Costco, Barber versus Nestle. Court dismissed for lack of standing without reaching the false advertisement claims. And Barber versus Nestle, alleging violation of the California Transparency Act, creates a private cause of action. But still, it was also dismissed. So. Chris?
Chris, are you going to talk about the Alien Tort Statute?
I certainly can talk about the Alien Tort
Perfect.
Statute if you'd like me to. And
Please.
yeah, this is the statute is also known as the Alien Tort Claims Act. It deals with civil actions by an alien for a tort committed in some violation of a foreign law, in international law. Now, and this used to be an instrument for litigation in this area. However, you probably remember the Kiobel case, that there's a presumption against extraterritoriality in this area. So, and therefore, there has to be a connection to the United States. The next case there, the Adhikari case, is one that, relying on Kiobel, affirmed summary judgment against plaintiffs in their ATS claim because the human trafficking occurred in Nepal, Jordan, and Iraq, even if it was affirmed by agents of the U.S. government. So when we come back to the original law that was passed, the Trafficking Victims Protection Act, and which actually provides criminal penalties. I'm on the next slide, obviously now. For whoever knowingly benefits financially or by receiving anything of value for participation in a venture which is engaged in providing or obtaining labor or services by any of the means enumerating acts of forced labor. And this does have extraterritorial activity under the reauthorization of the Trafficking Victims Protection Act in 2008. The Adhikari plaintiffs also brought those actions. The court granted summary judgment in favor of the defendants because it was never present in the United States. And the court originally permitted the TBA claim to continue against KBR, but reconsidered and granted summary judgment there also. So the one fact is that the act isn't retroactive. The act took place after 2008 or subject to the TVPA. So there was another case that I wanted to discuss that just came out late last year, and this is Keo Rafka versus Batana Seafood Company, and this is another one of these fishing cases, but this is a different one. This is brought under the Trafficking Victims Protection Act, and allegations of human trafficking in corporate supply chain. This is in the District Court for the Central District of California, and the court is allowing the case to go forward while dismissing some of the plaintiff's claims. This is the litigation. This is where you have this litigation risk for companies that know or should know that they're benefiting from acts of human trafficking. The plaintiffs here are actual victims or alleged victims of forced labor in factories in Thailand producing seafood for export to the United States. Defendant are both Thai-based companies and U.S.-based companies that import and distribute this seafood. They made their claims under the Trafficking Victims Protection Act, also brought claims under the Alien Tort Claims Act, and the defendant filed a motion to dismiss, again, arguing that the knowingly benefiting provisions don't apply to extraterritorial conduct, and that plaintiffs had not alleged facts sufficient to support the claims of human trafficking and forced labor. The court did not agree and said that it does. The Reauthorization Act of 2008 does apply to extraterritorial types of conduct alleged by a plaintiff, and that the scope does include civil action. There is a private right of action. Even though the Trafficking Victims Protection Act is a criminal statute, it does provide a private right of action for victims. So this private right of action is what is being used here. And the court also stated that they did dismiss the ATS, the Alien Tort Claims Statute, because they occurred on foreign soil, and they relied on Kiobel. So those claims were dismissed, but the Trafficking Victim Protection Act claims were in fact allowed to go forward. So this is I think this is, if you look at that language, whoever knowingly benefits financially or receiving anything of value from participation in venture which has engaged in, by any means, it's a fairly, I would say, loose standard. It really allows, as long as you knowingly benefit, and we've talked about how much information is out there about what's going on in many of these supply chains. So this, I think, is, and a lot of the information about this whole Thailand fishing industry came from a New York Times expose on that industry, and that led to some of the other earlier lawsuits. So I think this is a significant risk, and the court here is clearly saying that this is the kind of case that this language in the Trafficking Victims Protection Act was intended to address.
And so, Chris, we're gonna do the conclusions, but
Sure.
So what is a corporation or an ethical supplier or company supposed to do? Obviously you need to build in the appropriate contractual language to protect yourself. You need to allow for audit rights. But you need to also be careful, because if you go too far, too deep, or exert too much control, then you're going to run the risk of clearly exercising control, and then the joint employer standard will be easily satisfied. Next, as Chris mentioned, bad media is the worst. Is probably often more detrimental to a ethical company than some of the damages or liability results that may occur. And I know that's kind of the theories behind the false advertising claim causes of action. They call them shame and blame cases, because that's it's a difficult standard to actually get or impose liability on the company, but the idea is you maximize the social media or the bad publicity associated with it, and that's how you get action and results. Do you want to talk about?
Yeah, disclaimers on the website, that goes directly to one of it. I mean, again, Walmart had that beautiful disclaimer on the website saying we don't do this and we don't do that, and then we audit everyone. That was in one of the disclaimers on the Walmart website. And then the case said, well, if you audit everyone, why the hell did that happen, right? So, I mean, you want to have a disclaimer, but how detailed your disclaimer has to be for you not to be considered that's not going to go back and bite you, right? So you have to be cautious with that. Of course, it is a work in progress. It's an evolving area of the law. So as you see, there are new laws passing. There's a guideline from the OECD passing today. Those cases are all between 2010 and now 2016. So it is an evolving area of the law should be watched carefully. We also, the ABA, the American Bar Association, has a working group that was created to assist the companies in addressing the issue the best possible manner. And Chris, would you like to talk a little bit about it?
And so, Chris, we have on our screen the model principles from the ABA. So if you want to talk about that.
Right. Sure. The model principles are listed. There are four model principles: prohibit labor trafficking operations, conduct the risk assessment of the risk of labor trafficking and child labor. That's really one of the key provisions, because the risk assessment methodology basically says, look, what you want to do is you want to take areas where you have the greatest potential risk, and you want to investigate those, and perhaps the ones that have the most impact to your company because of the importance of the commodity coming from that, or the part, or coming from that area. So recognizing that a large company can't undertake a complete review of its supply chain, but if you go to places where you have the greatest risk and do those first, that gives you a sense for how to approach that. And then the third, you should train your relevant employees, engage in continuous improvement, maintain effective communication mechanisms with its suppliers, and devise a remediation policy. So these were negotiated over an 18-month period by the business law section in collaboration with a lot of other sections of the ABA on both sides of the spectrum, going out to the human rights perspective, and even the Chamber of Commerce and U.S. Council of International Business and others, outsiders who were involved in this as well. We have principles. If you go out to the website, you'll see principles and policies. The policies were not adopted by the House of Delegates because we couldn't get agreement across the ABA on the policies, but we could get an agreement on these particular 4 principles. And there's a lot more than you probably want to read in a few articles that I've written in this area, which are on the next slide, along with an excellent article by Fernanda and Ed on this area in terms of resources that are available.
And as a good segue, Chris, if we go back to the model principles, those principles look very familiar to the compliance officers in the group or to anybody in the compliance group, especially as it relates to doing risk assessments and then doing training and developing policies and doing effective remediation. So these laws at certain levels are all intertwined and interrelate, and the working group that the 3 of us are on that Chris is spearheading, hopefully in the April business law section or business law meeting, we will adopt some contractual language that will be available to the group so that we can effectively make sure that corporations know where the lines are or where the risks are associated with it. So.
Yeah, that's a good point, Ed. That contractual language. This is we're working with our UCC committee, which is looking at developing a mechanism to incorporate things like the ABA principles and other human rights protections into supply contracts, recognizing, of course, that if you can get some of these principles into the actual contracts that are devised by and negotiated between OEMs and suppliers and others in the supply chain, then there's a much better opportunity for enforcement within that construct than just using a policy to do it. So that's an ongoing project, and I want to thank Ed and Fernanda for being involved in that project as well.
Oh, thank you for inviting us.
Inviting is a nice term.
Chris is very so I think that concludes the formal presentation, and would welcome any questions from anybody on the web or in any of the offices. Otherwise, we'll have to tell more war stories, and Chris has several of them, so they're very entertaining. But right. So I think we have Phoenix up on the screen here in Indianapolis. So anybody in Phoenix with any questions?
Nothing here.
Okay. Chicago?
Anything? Nothing here.
Okay. Madison? Milwaukee?
Yes, I have a question. With respect to the California Transparency and Supply Chains Act, where you say doing business in California with gross receipts over $100 million, is that, what if you're in Wisconsin and doing $5 million of sales in California? Does that count, or do you have to have $100 million sold into California?
The 100
No.
Let me
Go
see
ahead,
if I'm
Chris.
off mute. Yeah, the 100 million is your worldwide revenues.
Exactly.
It's just you just have to be doing business in California, however de
Minimal
minimis
it
that
is.
may be. Yeah, and then they look at your worldwide revenues to come up with 100 million.
And it's the same theory as the UK standard as well.
Yeah, the modern slavery is the same.
Anyone else in Milwaukee? RDC. Okay, Tampa? DC? Okay, so I think we have 3 more minutes that we are kind of obligated to make sure we get our full hour of credit. So, Chris, I'm going to put you on the spot here. Do you want to talk about your experience with GM and Germany?
Oh, yeah, the experience. Yeah, that is an interesting case. We were talking about these cases, and if you look, this is a matter of public record that GM was sued by the descendants of slaves that had worked in GM factories that were nationalized during World War II, and because those factories employed slave labor, forced labor, and when GM took the plants back over in 1946, that the allegation was that GM had taken advantage of some of the fruits of that forced labor. So I mean, it just shows that these suits can go back. We had a similar suit in South Africa over the same thing about apartheid. We had sold our plant back to the employees and took it back over. So the other point that raises is that this becomes a due diligence issue when you're buying a business and I think one of those seafood cases actually involved they sued both the prior owner and the new owner of I think it was Little Frisky's cat food. I think Procter and Gamble owned it, and then they sold it to Mars, and then they were sued, and so there are a number of this becomes a number of issues since you're having more litigation. Just something to be aware of. The only other thing I'm going to mention, and we talked about this, there is a FCPA potential liability here as well. And as I mentioned to you, many of the workers overseas move from one country to another, just as workers in the United States move from one state to another to look for opportunities. And so, for instance, if you have workers, as happened in this Thai fishing, who came from Burma and ended up in Thailand and then ended up in slavery as a result of this fishing issue, where the FCPA would come in, if the company that was looking for the workers had hired a labor broker who went to Burma, got these workers, and then got them into the country, but got them into the country by bribing customs and officials in Thailand in order to get the employees in the country, and that labor broker, of course, was a supplier to the company looking for the workers. There you have potential FCPA liability, and this was actually discussed in the FCPA report that the SEC and the Justice Department wrote a few years back. They talked about the possibility of trafficking. So this is just another one of those areas where there's probably some potential liability out there. These labor brokers, as I mentioned, do employ some questionable business tactics in getting workers from one country to another, and may involve bribery, and they usually work on behalf of a company that's looking for workers.
Well, I think that concludes our presentation today. Thank you very much for attending, and please join us next month, March 9th, for the next BLT. Thank you.